The shooting death of Trayvon Martin. It was a case that captured national attention a little more than a year ago. And now the man who shot Martin, claiming he was defending himself, George Zimmerman, goes to trial in Seminole County tomorrow, with much of the world watching. We examine the case with two of the attorneys who know most about it today on Central Florida Spotlight. Hi, everyone, and welcome to this special edition of Central Florida Spotlight. Today, on the eve of yet another super high-profile trial in Central Florida, we have Mark O'Mara, the lead defense attorney for George Zimmerman, the man charged with second-degree murder in last year's shooting death of 17-year-old Trayvon Martin in Sanford. And later, we'll hear from Natalie Jackson, one of the attorneys representing Trayvon Martin's family. But first, attorney Mark O'Mara, who is heading into one of the biggest trials of his career, and we're also joined by our legal analyst, Bill Schaefer. Thank you both for being here.
Sure thing.
First, Mark, I have to ask about this because it seems like it's really the undertone of the entire trial. What about the societal issues? Are you in the state aware of this, and will it affect the way that you proceed in courts?
We're certainly aware of it. It's not supposed to be an effect on the way we handle this in court, but the reality is it has been since day one. This whole case has had such an enormous societal focus that you can't ignore it. Every protest that was talked about, every reason to arrest that was brought up, was really brought up because of the undercurrent of the social or the racial currents of the case.
So as you go forward and as you move forward in preparing for this, can you use any of that to your benefit?
Well, a couple of problems. We have to address it in the upcoming jury selection. We can't not address both the publicity that it's gotten and then the basis for that publicity. So in jury selection, it's going to be of paramount importance. It truly shouldn't have an effect in the jury itself, with the jury itself at the trial, but we don't know how the state's going to handle that. We don't know how the state's going to bring something up. As you may remember, in the very first hearing we had when they came up with the word profiling, and I sort of asked them, in a very pointed way, what they meant by that, because obviously the undercurrent of that is racial profiling, and that was a big issue at that point. So even though you don't say the word racial, you can't help but know that the jurors are thinking about it, and the witnesses maybe as well.
Well, that leads me to a question, which is how difficult do you believe it's going to get a jury at the epicenter of this case in Sanford, Florida?
I think it's going to be difficult to get one, but I think we will get one. The problem with sitting a jury in this case is going to be the enormity of the pretrial publicity and how it's affected people. Now, you know, the OJ case, the Casey Anthony case had a lot of publicity, but in this case, it's publicity to such a deep-rooted social event or social undercurrent, that being racial relations and how blacks are treated in the system. And because that's there, we have to really be able to sort of root out and to identify if those biases exist so that they don't show up in the jury room.
Okay, so depending on how the state really triggers their painting of your client, George Zimmerman, will that determine how you paint Trayvon Martin? So much has been made about, you know, looking at his past and looking at his drug test and whether or not that should have been a factor at all. Clearly, you guys have been doing some digging with what's happened in his past. Well,
and there's a bunch of different filters that we have to look at. The first filter is what is discoverable, and that's wide open in Florida. So everything that we can find out about Trayvon Martin, his family, his upbringing, whatever it might be, we have to, as good lawyers, look at, just like the state is looking at everything they can find out about George Zimmerman. That's the wide open filter. From that, it has to now be relevant evidence, and that's much less. They might make information that would otherwise not be relevant by the way they act, the state might, and then we'll react to that.
You know, that leads me into questioning you about this another significant aspect of evidence, which is the experts. And we know now that Dr. Reich, if I pronounce his name correctly, has made some startling and bold statements and assertions. Do you view the expert testimony as your second biggest hurdle, and what do you think about that, and what do you plan to do about it?
Well, strangely to say, and I'm not just trying to reinterpret or reinvent the wheel, I think that the expert testimony is going to be the toughest job for the state. They carry their burden in this case. They have to convince that jury beyond a reasonable doubt that that expert testimony shows them something. Does away with reasonable doubt is what they have to show. And we know at the very least all of these experts have conflicting opinions. some of the state's own experts are disagreeing with the modalities used by the others. So I look at it and say this is going to be much more confusion than it is going to be assistance, which is why I filed the motion to say we shouldn't have it if it's not concrete.
All right, we're going to talk more about that and how that actually might play into your hands as we continue our conversation with, again, George Zimmerman, lead attorney Mark O'Mara. That's after the break here on Central Florida Spotlight. Welcome back to Central Florida Spotlight. We are less than 24 hours away from jury selection in the George Zimmerman murder trial, and we're joined by Zimmerman lead attorney Mark O'Mara and our WFTV legal analyst Bill Schaefer. Mark, we were talking before the break about the whole 911 calls and all the experts who someone heard this, someone heard that, and there's 6 or 7 conflicting conversations among the experts. Could that be to your benefit because there's no real exact, this is what was said on that 911 call?
Well, I mean, 30 years of criminal defense attorney experience on this side, another 30 or so on that side, and I think both of us would agree that the state carries the burden of proving this beyond a reasonable doubt. And a confusion of the evidence, a conflict in the evidence is said very specifically to be one of those places where the jury can find reasonable doubt. So the fact that we don't have any experts that tell us conclusively what happened, I think is going to be very telling for the jury.
Now, we know that neither you or the state wants to bring before the jury or have them consider what Greg was talking about earlier, which are the societal issues in this case. Are you concerned, however, that outside of the courtroom, you're going to have 2 distinct camps here? You're going to have your Second Amendment individuals, and you're going to have strong supporters of Trayvon Martin. Are you afraid that there may be a clash of those 2 outside of the courtroom?
I'm very concerned about that. I've said since day one that though I don't oppose the conversation about how young black males may be treated in the system, this is not the case for it. And I'm very afraid that, I mean, someone said that this was the most significant civil rights case of the century. Let me be very clear. That's absurd. This is not a civil rights case.
This case has been called, Mark, a stand your ground case from the beginning, but you've turned it to self-defense. Talk about that.
Well, first of all, it's not a stand your ground case. Stand your ground applies, if you look at the spectrum of self-defense cases, stand your ground is way at the end. Stand your ground truly applies when you have an opportunity to retreat and the law says you don't have to. So you're in fear of great bodily harm, you can walk away, you don't have to. That's way at the end of the spectrum. George is right here in the middle or at this end of the spectrum where he had no opportunity to retreat. So it's not stand your ground. It is traditional self-defense. The evidence supports that he was on his back with Trayvon on top of him. There was no opportunity to retreat, so it wasn't a voluntary decision that he would have made not to retreat. That's why I keep saying this is a self-defense case, and quite honestly, it's also not a stand your ground hearing. It's a self-defense immunity hearing because that's exactly what the statute affords a defendant.
Is it not the case, it seems like it's been a matter of public record, that the non-emergency operator did say to George, are you pursuing something to that effect? And he did continue. So is there a reset button in there that allows him to claim self-defense when what appears to be he was the one going after Trayvon?
Well, first of all, there is a reset button. We'll talk about that in just a second. Remember also the non-emergency operator said on 2 separate occasions to George, what is he doing now? I think that would suggest to most people, keep an eye on him, what's he doing now? It was exactly what George was doing. He was already out of the car. He was trying to find him because Trayvon had already run around the corner. And when the officer said, are you following him? He said yes, and he said, we don't need you to do that. And George said, okay. There's no evidence to suggest that George was following him after that. But let's talk about the reset. Under the law, even if you are the initial aggressor, which we contend that George was not, but even if you were the aggressor, if you show that you are no longer being aggressive, then the button can reset. I would suggest that the only forensic evidence that exists with Trayvon striking George and George never striking Trayvon would suggest that even if George was pursuing, that Trayvon became the aggressor when he struck him. Not to mention, George following is a legal action. It is not illegal to follow somebody. It's not illegal to watch where somebody's going, particularly when an officer asks you to do so twice.
Couldn't Trayvon still, under all rights though, beat up George Zimmerman if he was fearful for his own life?
He can only react to force with like force. So if George had taken out a gun at that point, maybe so. But there's no evidence to support that. What we do know is that George never acted physically aggressive towards Trayvon. Let's not forget, Trayvon did not have a bruise on him but for the fatal gunshot. So there's no evidence to support that George acted physically towards Trayvon. The only evidence that does exist is that Trayvon struck George in the nose, smashing it, and that was the first physical event.
Found not guilty, can George Zimmerman ever regain any sense of normalcy?
No, absolutely not. I don't think he can ever walk the streets again, because there will be a percentage of the population who believe that that was an improper or an unfair verdict. And my fear is, George's fear is that they may try and equalize the sides. They may try and revenge justice.
I guess at the end of the day, no matter what the verdict is, there are no winners.
Absolutely not. The Martin family has lost their son, and George Zimmerman has lost his freedom in the sense that he can't walk the streets of America, the country that he loves so well.
Okay. Thanks for being here.
Sure.
Okay. Up next on Central Florida Spotlight, the other side of the case. We'll ask similar questions to Martin family attorney Natalie Jackson on the eve of jury selection in Seminole County. That's next. Welcome back to Central Florida Spotlight. We just heard from Zimmerman defense attorney Mark O'Mara. Now to Martin family attorney Natalie Jackson. Natalie, first of all, thank you for being here.
Thank you for having me.
Here we are. I mean, we're just 24 hours away. How is the family handling the emotion of almost being in court for jury selection?
I think that at this moment, they're probably, knowing Sabrina and Tracy, they're in prayer. They just want this to be complete so that they can move on. They've had to deal with this for a year and some months now. They just want, I think right now they just want to grieve. They haven't had a chance to grieve.
One of the big things, the underlying theme to this entire process have been societal issues, the race issue. What's your thought on that as we now head to the trial? Because this could be a tinderbox of such emotion.
Well, I think that people will realize that this case is not really a race case from the state's perspective. The prosecutor's perspective is that this is a murder 2 case. And from the defense perspective, they may want, there may be an issue as far as to talk about motives of what the police did. But from the prosecutor's perspective, they chose not to say that this was racial profiling. They said it was criminal profiling, that Zimmerman profiled Trayvon as a criminal. So I think that's interesting that they stayed away from the race issue. While, clearly our team, we did say that this was racial profiling. We saw this case as a vigilante who was a armed neighborhood watch officer that killed a teenager who was supposed to be in the neighborhood. So when the racial component, I believe, came in when, really, if you ask me, it was when members of the Zimmerman family got on television and said that he's not a racist. When no one on our team ever charged him with being a racist, we said that he racially profiled Trayvon.
Have you been in touch with any groups, organizations that plan to come into town, and are you working with them to try to keep things under control so they can make their views known, but by the same time in a peaceful manner where there won't be a clash between these two parties?
Well, we haven't gotten any indication that there's parties coming from out of the state. And I'm not sure if that's going to happen because we haven't been in contact with them. However, I do know that it's very important for Sabrina and Tracy both that people understand what the protests were about. The protests were about the fact that an armed man shot and killed a teenager in a neighborhood, and he was not arrested. And he was allowed, from our perspective, to hide behind a law that did not apply to him, which was the Stand Your Ground law. So the protest was about arrest George Zimmerman. So whatever the outcome of a trial, that is what a jury decides, and that is what they will respect.
So, Natalie, are you saying that if, in fact, George Zimmerman is found not guilty, that the family is going to say, and your position is going to be, respect the process, we may not agree with the verdict, but we are happy that the process unfolded the way it should have unfolded?
Right. That's what their quest has always been, an equal and fair process for both the victim, which is their son, and the defendant, George Zimmerman.
We asked Mark O'Mara, how will George Zimmerman be portrayed? In his opinion, how will Trayvon Martin be portrayed? I know that you're not part of the state's legal team. You're with Tracy and Sabrina. But how should George Zimmerman be portrayed in your eyes, knowing what you know about this case?
I think he should be portrayed who he is and what his, what the evidence will show that he is. I think that Trayvon was a victim here. George Zimmerman knew nothing about Trayvon. He didn't know, he didn't even know his name when he saw him. So I think that it would be, the stuff that is relevant for a trial should be what is introduced here.
Not the things about Trayvon's past is what I guess that maybe you're driving at, because I know that that's been a part of discovery. There's even been a drug test on him in his autopsy, this sort of thing.
Well, if you're going to talk about Trayvon's past, first of all, you have to understand that he does not have a criminal record. He's never been arrested. He was an average student, an ABC student in school. He was 17 years old. He was on a college track. He has a college-educated mother. He has a brother in college. So if you're going to talk about Trayvon, then that's what we have to talk about. So as far as the portrayal of Trayvon in trial, I think that it will be what George Zimmerman knew of Trayvon. And what we know is that he knew nothing of Trayvon.
All right, this is an interesting conversation. We'll continue talking about that. We'll talk about where the media falls into this, and also the multimedia with all of the Facebook and Twitter and YouTube, and the way that this thing is going to just generate immense notoriety. That's next here on Central Florida Spotlight. Welcome back to Central Florida Spotlight, joined by Martin family attorney Natalie Jackson and WFTV legal analyst Bill Schaefer. Again, thank you, Natalie, for being here on the eve of jury selection. There has been talk of a couple of things. One, that we couldn't find a jury in Sanford, which is where the Seminole County Courthouse is, and that this trial would have to be moved. What's your take on that as an attorney?
I thought that was pretty preposterous. In today's day and age, you're going to have cases that are in the media. You're going to have people talking about them. We've seen two national trials that went on where a jury was able to be found and a verdict was able to be reached. Jurors get instructions from judges, and usually they follow the judge's instructions.
How about the sequestering or the anonymity of the jury? Because that's what Mark O'Mara would like from his vantage point, to have complete anonymity so that somebody could cast a vote in the jury room and not fear any reprisal.
Well, I think anonymity is good. I think that we've always respected the jurors' privacy and their, the fact that they should remain anonymous unless they come forward to talk about it. So we don't have any problem with that. I don't know if there's a need for sequestration, but, it will be what the judge decides.
Natalie, there's been some perception and discussion that your team and the prosecutor's office is working hand in glove, and that some are even saying that you are directing the prosecution in their prosecution of this case. Is there any truth to that?
No, there's no truth to that. And in fact, I think the prosecution might even see us as kind of a hindrance to their case. The prosecution likes to keep things very close to the vest. One of the things that I think a lot of people don't know is that we are not getting any special information from the prosecution. We see when a motion is filed, we see it when it's public. I see it on, on your news channel, on Channel 9, or through the newspaper. So we're not getting any special information from them, and they're not really taking any direction from us.
What do you envision your role to be if there's a not guilty verdict, and what do you envision your role for the family to be if there is a guilty verdict in this case?
Our role has always been advocates of this family. So our role has always been to be their guidance. And in this case, because we've become very close to the family, we're legal guidance, and we're also friends. So our role is to make sure that they're not harassed, to make sure that they are not portrayed in a light that they don't want to be portrayed in, to protect the reputation of their son, who is 17 years old, and to make sure that their interests are respected in this process.
What role has the internet played in this, or will it play?
I think it's played a huge role. It played a huge role in the process of justice. When we talk about the protesters, it played a very huge role, because I believe that one of the impetus to having a proper investigation in this case was the fact that you had social media and bloggers and petitioners they participated in this case. One of the big stories I think that will come out of this is the fact that of Kevin Cunningham, who was a Howard University student that started the Change.org petition. That petition got 2.2 million signatures to arrest George Zimmerman. These were people that said, you don't just get to go home after you shoot and kill an unarmed teenager in a neighborhood he belonged and he was supposed to be in.
I can't let you go before I ask you one of the questions from earlier, before May 28th and the proceedings there, with all the different scientists hearing different things on this witness phone call. What does your side say that was heard there?
We have always said that we think that it's Trayvon. We agree with some of the witnesses who've testified that it was a high voice of a young person, and that the scream stopped when the shot went off. And so, you know, I think that whether or not you have experts, it really doesn't matter, because a jury will hear this. And one of the things that the jury will be told from the judge is that they're allowed to use their common sense. When I read the expert reports, the only reaction that I had, it took me back to the day when I listened to that tape for the first time, because I listened to it with Sabrina Martin, and it was the first time that she had heard it. And I will never, ever forget that moment, because I could not imagine, as a parent, listening to your child beg for his life and someone still pulled the trigger.
Okay. And that'll do it for this special edition of Central Florida Spotlight. Remember, Eyewitness News is the best source for your Zimmerman murder trial coverage. Legal analyst Bill Schaefer and I will be in our mobile studio from gavel to gavel. We will also have extensive online coverage on WFTV.com, as well as on our mobile app and through Twitter. And we'll be doing weekly recaps here on Spotlight throughout the trial. Until tomorrow, thank you to our guest, Natalie Jackson, Mark O'Mara, and legal analyst Bill Schaefer. Take care.